have a copy of the minutes, any additions or corrections? Not, entertain a motion to be approved.
Motion for approval.
Bill, seconded. All in favor? Okay, it's unanimous. You have a copy of the transfers. Are there any questions on the transfers? If not, I'll entertain a motion they be approved.
So moved.
Calvin. Charlie, you get your name on the book.
I'll second that, yes, sir.
Somebody better wake up.
Any questions? All in favor? All right, it is unanimous. Bills and hand checks, any questions on any of those? If not, entertain a motion that they be approved. Rick? Bill? Any questions? All in favor? Unanimous. We need to note in the minutes that the sheriff fees turned in $758,126.01. Property tax turned in by the sheriff, $493,178.43. Clerk fees, $85,588.11. Also, we have to approve the clerk's fourth quarter report, and Glenn has that, which he can explain to you best he knows how.
That may be an assumption.
I will say this is routine.
What you have, or what I have in front of me, is a summary and reconciliation of all the accounts from the clerk's office for 2014. And in summary, it says beginning balance plus receipts year to date. The fee account budget estimate was $11,152,656, but the fee account actual turned out to be $11,679,703. And there are some book balances as of the date of the reconciliation, but essentially what you need to do is to vote that acknowledging that you are in receipt of this annual summary and reconciliation.
Is there a motion to that effect? Charlie? Any questions? All in favor? Okay, that is unanimous. We have Mr. Bill Pickering and Dirk Burcham about the road facilities, and Bill, you first. We need, when they get through with their explanation, we need to vote to accept or reject the bids and move forward with that, but.
All right, hello again. Thank you. I'm Bill Pickering with CMW. This is Dirk Bertram with Codell Construction. We have two things to do tonight. One, we wanted to just give you an update of the status of the project. I know that many of you are new to this, and so you're coming in during the middle of the project, and so wanted to make sure that you had information, that you were informed. And to let you know that outside of even tonight, if you have any questions, questions come up, you're free to give me a call, give Dirk a call, and we're open to that. We actually, we'd like to see that because, again, it's most important for us that our client is informed and understands where we are and what's going on. So I submitted to the judge a few days ago, and Dirk did also a sort of a brief overview report of the project, to give you all an understanding of kind of what the scope of the project is and the parts and where we are right now. And so first of all, just to briefly go through that, this is the report I'm talking about that the CMW submitted. And the first page is just to give you a quick overview that this is the replacement facility for the road department, and it involves the development of the new site for the buildings, and then it involves 4 buildings. The first building is the salt barn, and that's been built, or it's been bid, and it's now under construction. And what we'll be talking about tonight in a few moments will be the equipment sheds. And that's this building here and this building here. The 2 buildings comprise the equipment sheds. And you'll be acting on the bid that occurred in December on that tonight. And then the third component will be the remainder of the site development and the maintenance building. So on the next page is just a quick overview of the salt barn, which is building under construction now. This is not the salt barn, but this is a picture of a similar salt barn. Yours won't be green either. So this gives you a sense of what the shape of the building looks like and the size of the building. So there's some, I won't go through the details, but I just, on each of these pages, for each of the building components, I described the scope of what this part of the project was. Gave you information on what the bid scope, what the bid was for the project, what the cost for this portion, and then what the current schedule is. The next page is the equipment sheds that we're going to be talking about in a moment tonight. Two separate equipment sheds, scope and the size of them, the bid, the low bid, and what we'll be talking about tonight, and the action we'll be taking. And then the third part being the utility extensions off-site, and then also the maintenance building on-site. Again, a quick overview of what that building is, a rendering of what the building will be looking like at the end, and the current schedule, and then just the floor plan and some modeling of what the mass of the building looks like. So with that first, do you have any questions at this time about the project in general? If not, I'll go on to more specifically tonight with the equipment sheds. The project bid in December 18th, and the low bidder we reviewed extensively, had some questions and some clarifications that had to be worked through, and we did that, and the low bidder with Codell Construction submitted their response to my inquiries of various issues, and I was satisfied with their response, and I had recommended that the totality of their response, that documentation, become included as part of their bid form submittal. So when they submitted their bid, I viewed that our subsequent review of their bid as being additional information and therefore a supplement to the bid, and therefore it should be included as part of the contract at which time when it does get approved. And so tonight, the discussion would be the actions that you'll want to be taking is presuming that you approve the bid. The first action is to make a motion to approve, accept the low bidder, and once that is done, then to make a motion to award, assign that contract to Codell Construction. They are the construction manager at risk, and what the process is after you've accepted a low bidder, all the contracts are being assigned to Codell, so that the county, at the end of all of this process, you still only have one contract that's with Codell. To you, they look like a general contractor, and all the contracts or bids are assigned to them, and they manage them as subcontractors. So then it'll be the assignment of the contract to Codell, and then the third motion is to authorize Codell to proceed with construction of the equipment shed of that bid. So with that, we'll start with the first part, which was the acceptance of the low bid. Dirk, if you want to just go through what their low bid was.
In my report there on the third page, if you have that in front of you, I've got my bid tab. We received 2 bids for the equipment sheds. The low bid was Rising Sun Development at $1,119,000. The next bid was $1,475,000. So a difference of about $350,000.
And the low bid is also was below the budget amount for the scope of the work.
Correct. We budgeted about 1.28, $1,128,000. So it was under budget.
I have one question. Glenn, have you reviewed the additional information we had to request that doesn't violate any of our bidding process in any way, does it? I just want to make sure we're not.
In terms of assigning
Yes.
the bid? No, that tonight's first I've heard of that. There's obviously no issue about accepting the low bid for the equipment sheds. Bill, let's back up a little bit. Alvin asked a good question. In assigning the bids to Codell, what are you looking at? What are we doing?
You're just making the motion that once you've agreed to the low bid, you're then assigning that bid to Codell as a contract.
The same thing we did on
Yeah.
the salt barn.
Yep.
Correct.
My question, I was not questioning that part of it. Mine was the additional information you had to ask for when you got the two bids in. I just want to make sure we're not doing something, when you
Okay.
ask for more from one company, that we're not doing something that
No.
invalidates the bid process.
The bid documents allow this. What happened is, when they submitted the bids, we went with any low bidder. We reviewed that bid, and because there was some questions about it, I wanted to clarify to make sure that they were in full compliance with the specification requirements. And so those were the discussions we had, and because, we had those discussions, I wanted to make sure that there was a public record of that discussion, just to address exactly what you're describing. To make sure that there was not any, modification or adjustment made after the bid submittal that would modify, that would give them unfair advantage. So that's why that record, and what the document that was prepared and submitted by Codell that you should all have, everything is documented, is in just a document that is in full compliance with what's specified in the documents.
Both
And that's
bids
what we
met-
were just wanting to confirm.
Both bidders met the specifications.
I did not go into detail with the second bidder because I didn't need to, because there was no, we were first evaluating the first bidder. If there was any question that they didn't, because if there was any question that they didn't meet the specs, then we would have that discussion of not accepting their bid and going to the next bidder. And then I would have done the same process.
So the first bidder met all specs no matter what.
That's correct.
The questions you asked from the first bidder were just clarifications.
That's correct. That's correct.
Did not change any cost, did not give them any advantage over the second bidder.
None whatsoever. And so the process that we went through is a standard process that is defined by the documents, that it can happen as necessary, that we can ask for additional information to clarify and make sure that the bid is in compliance
Okay.
after the bid.
In that
That-
case, I
That-
move.
That should be
I'm sorry.
fine, Mr. Lyons, yes.
Okay. In case I move to approve the low bid.
Is there a second? David, any further questions?
I had one question, Judge. There was quite a difference between the low bidder and the additional bidder. Did you get any feel of what the difference would be? And one of the reasons why I asked that is I've been involved in these projects before on the city side. And sometimes what will happen is that there'll be a low bid and then there's a ton of change orders coming through. So I guess can you address that question as well as make sure that all the specifications were met in terms of what they are bidding on to meet our criteria?
Yeah, Rising Sun's from Lexington, a little closer. Frederick and May's from down in eastern Kentucky, so you've got the travel. Rising Sun, from what I could tell from the bids, were subbing less of the work out, so there's less markup involved. Frederick and May was subbing just about all of it out. That's a pretty good difference right there between travel, location, mobilization, and what I explained there. That would be most of it. I'd have to dig deeper.
My experience with the two bidders is the low bidder, as a general contractor, is more accustomed to this kind of work than the second low bidder. Now, the second low bidder, one prime reason I would believe that he bid was he's already on site. He's the earthwork contractor for the first bid, for the salt barn. So he did have some benefit there, but again, as Dirk said, if he's bidding out everything as opposed to being able to self-perform it, then he's having to incur markups from subs that the low bidder didn't have to incur.
Okay. Thank you.
Any further questions? Go ahead.
I'm just wondering, so this is all-inclusive, these folks are a general contractor?
Yes, sir.
And then they've got
We
other subs?
work with them on several projects. They're top-notch contractor, and.
And you said they're out of Lexington?
Yes, sir.
And so they'll have, but they do have subs, or they're doing a lot themselves, or?
The only sub that they'll have will be the actual erection of the metal building. They're gonna put in the foundations themselves, the storm drain, anchor bolts, all that type thing. The only thing that they'll have is they'll have a supplier for the metal building and then somebody putting it up there.
Will these be fit up with water, electric, or anything like that, or is that part of?
The equipment sheds, based on how we've organized the project, has limited, because they're outdoor sheds, there's just a minimum amount of electrical rough-in on this phase. The remainder of the electrical that will go into the equipment sheds is going to be coming out with the maintenance building. So that electrical contractor will have all that component. And the reason is, because we knew how we were moving forward with this, it made most sense from a package standpoint. The electrical work that's going to be in the equipment sheds is all going to be surface mounted. So it didn't have to come now and bog this project down, as you say, in that respect. We were working to get the schedule moving forward and get these things into construction to deal all with the weather and everything else. And since we were going to have an electrical contractor on the maintenance building, it seemed reasonable to let that package have these peripheral pieces, which would be small package items otherwise.
Any other questions or comments? If not, all in favor? Okay, that is unanimous. Now, the second thing is to assign the contract to Codell Construction. Need a motion to that effect. Okay, Charlie and Bill. Any questions or concerns?
Let me just interject here that also that was, the assignment is typically based on also that there is no objection from Codell Construction. In this process, you can have an objection from a construction manager who has had problems with the low bidder on other projects and have some basis for some, argument at this point. As I understand, Codell has submitted a letter and has indicated they have no objection whatsoever.
Correct.
Okay. Any other questions or comments? All in favor? Okay, that is unanimous. Now, what's the third thing?
Is just to authorize Codell to now proceed with this part of the project.
Okay, need a motion to that effect. Alvin, David, any discussion? All in favor?
That was it, and we're moving forward, continuing.
Yeah. Thank you, Bill.
Thank you.
Dirk,
You need this bid.
I thought you were gonna have to do it, but they didn't, so.
It's okay.
David,
Good evening. I had one of my EMTs resign to go to another business here in town. It's not EMS related, so I have a replacement for him tonight. Uriah Tyndall, URIAH, $8.49 an hour with benefits. And he replaces Joe Thomas, who's at $9.21 an hour. And he'll be going to part-time at $12.50, which is our standard EMT part-time rate.
need a motion to that effect? Rick, Chad, any questions? All in favor? Okay.
And then the second item we had tonight, I had a request actually through one of my paramedics who teaches for Franklin County Schools. They requested one of the surplus stretchers that's no longer serviceable on an ambulance. It was damaged in service last year. And they requested that they could use it for their emergency procedures courses at Franklin County Technical Center. And I have a letter from the principal there. The advantage that I see to that also is that with their emergency procedures class, that is potential EMS folks coming out from Franklin County to go to Eastern and potentially come back to us. So there is a benefit to surplus and to our neighbors. I do have a verbal request from Scott County as well. I just don't have anything in writing for one of the other stretchers. So they also want one from one of their emergency procedures.
Who was it going to, David? I'm sorry, I was reading something. Who is it going to be surplus to?
Franklin County School System.
Oh, okay.
So that's from one government agent to another, we can do that.
David, is that the one that was in the rollover wreck?
No, sir.
It's-
That one went to John Goble. That was the power cot that was in the rollover.
Oh, but we do have another cot that can go to our school system. Okay.
Yes.
Is that cot readily available? Or
Yes.
Is the reason they don't already have it, they just haven't made the proper request here at ECS?
I just was waiting for a letter in writing, request from the school system in writing.
And I'm guessing these are the cots that the power lifts replaced? Is that where they came from, or basically.
They're ones we pulled out of service that we were gonna surplus anyway, so.
Motion to approve the request.
Is there a second? Rick, any questions? All in favor? Okay, unanimous.
And then lastly, the ambulance and the dealer and I met a week or so ago. They had a chassis that was available at the plant where we awarded the bid. So barring any major complications on the build, we should have the ambulance by May. So,
When?
May.
May. Okay. Any questions for David? Thank you, David.
Thank you.
Where's that resolution? The County Judges Association and Magistrates Association asked all the counties to pass a resolution concerning the road fund tax money. And if you're familiar with what we're talking about, the money for the roads comes from the gas tax, and it's based on the average wholesale price. And with the average wholesale price going down, the tax money that we get goes down with it. And it's gone down 10 cents according to the Transportation Cabinet. And according to the letter that I got from them, from the road, it's gone down on an annualized basis for the state, $129 million. So that's more than $1 million per county. And it could go down further. And what this resolution, if you support it, is not to raise the tax or do anything, just stabilize it where it is. And one of the things that's critical about it, according to the way the law is written, if the gas goes back up to $5 a gallon, you can only raise the amount that it's gone down to by 10% a year. So it would take, to get back to where it is now, according to what Transportation Cabinet says, about 8 years to get back to where it is now. And this affects state roads in Scott County and every county. It also affects the amount of money that we get from the state. So it's the situation that was brought up at the at the legislature the last time they met, and it was higher then. It's been dropping since then. It was like $60 million that it was going to lose. Now it's $129 million and still going down. And the resolution is asking the state to just stabilize it. You know, don't let it keep dropping. And I would challenge you to go out and look, not at the county roads. County roads are in good shape, but look at the state roads and off Miners Branch Road, Indian Creek Road, Double Covered Road. Drive across those and see if they can stand the loss of this revenue to the county, and to every county. And also, we get 1.1 million from the state for our road funds for the county. And it will affect that. Now, how much it'll affect it, I don't know. We'll find out in February when we go to the budget meeting. But Glenn's got the resolution, and I think we should pass it, but I'll let him read it, and then we can discuss it.
This would be entitled Resolution 15-01, a resolution supporting passage of road fund stabilization by the 2015 Kentucky General Assembly to ensure adequate funding of the state road fund and county road aid throughout the Commonwealth of Kentucky. Whereas safe roads are deemed an essential public service provided to all drivers in the Commonwealth of Kentucky, whereas stabilizing Kentucky's road fund is vital to continuing safe roads in every county. Whereas Kentucky House and Senate leaders have acknowledged the need for action this session to ensure state and local road safety and avoid increased strain on state and county budgets. Whereas road fund stabilization has been one of the top priorities for the Kentucky Association of Counties for the last 2 legislative sessions. Now therefore be it resolved that the Fiscal Court of Scott County supports legislation to stabilize Kentucky's road fund ensuring continued safety for all motorists throughout the Commonwealth. Be it further resolved that the Scott County Fiscal Court strongly encourages the Kentucky General Assembly to enact road fund stabilization during the 2015 session as soon as possible to avoid further erosion of the state road fund. It has a signature line and a date.
Any questions on that or concerns? If not,
I was gonna say, it's actually scheduled to take another 5-cent drop in April.
it is, so that would be another $60 million.
Well, I wanted to make a couple of comments. I did quite a little bit of research trying to understand if my research is correct. They tagged the tax to the gasoline price in 2009. That's when it started. What we have right now, and I believe that it can be changed quarterly, 4 times a year, I believe. But there is a cap of about 10%. It can't go up over a calendar year. And I was just looking at some of those figures, and you were talking about the state of our roads now in Scott County. And I couldn't help, my first thought was, I see the money that they have taken in over the last 4 or 5 years since this thing was enacted. There was one quarter that they were we were paying, taxpayers, at the pump, 30 cents a gallon. That's been, it was either in 2013 or 2014, I don't remember. But I tracked it on January of each year from 2000. I won't go through all of that. But in 2000, 2004, it was 15 cents a gallon. They had a flat rate, and they raised it occasionally the following years until 2009 when they tagged it to the price of gasoline. They just tagged it to that and on a graduating scale. And there's a formula that they use to come up with it. But my concern is I didn't hear them screaming in 2011, 12, 13, 14 when it was a record windfall. And I personally, and I heard this even on the campaign trail, folks talking about what the state did with Broadway. I have one fellow said to me, what are you gonna do about a perfectly good 4-lane turned into a 2-lane and bicycle pass? I said, well, that's already done. I can't do anything about it. But that's the way they've spent that money. I'm a little bit concerned about just saying, hey, guys, fix it. Really? So I'm a little bit concerned about this. This is kind of so open-ended. What is their solution? What are we encouraging them to do? I don't see that in here.
I think what they're encouraging to do, Rick, is not just keep dropping another 5 cents and another $60 million.
Well, I think the figures, I think it's 26 cents.
Yeah, it's dropped 10 cents according to this letter.
Well, it's 26 cents this month, I think.
Yeah.
So that has to maintain for 3 months, a quarter.
Yeah.
Which is a 40% increase in from 2009, 2010 figures. So I guess my point is I'm a little bit concerned how they handle the funds, whatever the amount is, and to encourage them to just open-endedly. That's the way I feel about it. It's like an open-ended encouragement. Fix it. Well, how are you going to fix it? This was a fix in 2009, but all of a sudden it's taken a dive, and I personally don't think, but I'm not a prophet, so I don't think these oil prices are going to stay down, and I'd kind of like to know what the fix is before I encourage them to fix it. That's it.
Well, the bottom line, it can continue to go down. And if we stabilize it, that's far down as you can go, and it can go back up at 10%, which, 10% of a dime is a penny, So that's what they're asking, to pass the resolution. And of course, you for it or against it, but I do challenge you to ride out and check these, particularly the state roads. And I don't know, Alvin, you live down Miners Branch.
Miners Branch is a disaster area. We've been begging for attention for a while.
I had a lady yesterday, I was at a meeting, and they live on Indian Creek Road. She didn't even know this was coming up. She said, can you do something about Indian Creek Road? Said the UPS guy said he was going to have to change vehicles because it was so rough. back and forth across the road, that he was gonna have to change vehicles. And that's what we've got, but if we don't, and it's gonna affect the county roads too, but by the money that they give us. And we've kept our money, our roads up pretty good. We've got, in the last 7 or 8 years, we've probably got at least, JR, 10 more miles of road than we had 7 or 8 years ago. And to maintain those at the less money, plus the fact that we all know what's going to happen to the incentive money we gave, and Ms. Johnson told us that their revenue was going to be down this coming year. So with revenue going down, we got, do we want to take care of our roads or not? That's my feeling on it. But that's the resolution, that's the explanation, and
Judge, is the request for approval by the court, is it time sensitive? And
yeah, of course.
it needs to be, the impending sessions on
Yeah.
the.
They've asked every county. We're not the only county that they ask, and I'm sure there's some counties that feel the same way that others feel. But I'm telling you how I feel about it.
Yeah, I understand Magistrate Hostetler's concern about the glaring example of Broadway. I know that didn't suit a lot of people in the community and stuff, and still to this day doesn't. But it's imperative, I think, that as the governing fathers of the county, that we need to relay a message to Frankfort that to basically stop the bleeding on the loss of funding for roads, especially here in Scott County, because of our we're an economic driver, and we need to continue to do that. And the only way we can is through proper funding, and for the safety of our children, and just we have a lot of more traffic probably than vast majority of even central Kentucky counties. So I think that I would suggest, like the judge says, that we act upon this.
Well, and Judge, and you and Charlie can probably chime in on this, but explain the process about how you have to get on the plan. You have to, I believe it's a 6-year plan or 7-year road plan, and then once you get on the plan, there's funding mechanisms and.
Oh, yeah.
Yeah.
Well, the
It's not
6-year
just-
road plan is probably a 20-year road plan.
Yeah.
The 6-year road plan, the bypass was been on the 6-year road plan for 30 years, and we finally got it. And I don't think that has to do with rural and municipal roads. This has to do with maintaining roads like the ones I mentioned, Double Culvert Road where the landfill is. Drive across that sometime. And if we don't have the money, if they don't have the money, the state, and who's that on Ironworks Pike?
Me?
You. Okay, you get the complaints out there.
Yes, sir.
Okay, that's the money that we're talking about to take care of roads like Ironworks and those.
Yeah, I guess my point is that the legislature would be less likely to put roads into the road plan if there's a limited amount of funds, and then once it gets on the plan, it takes a longer time to get it done. And if they see that, I guess the forecast is glim, then they're probably less likely to put roads in.
The 6-year road plan, I don't know the answer to that.
Yeah.
The legislature's put a lot of plans on the 6-year road plan. The 6-year road plan, if there's $1 billion going to be spent, there's probably $10 billion in the 6-year road plan.
Mm-hmm.
And then who gets it is political, as you might know, and need. But I don't think, Chad, that has anything to do with this. I don't think it does.
Okay.
This is rural and secondary road money that we're looking at.
Well, I want to clarify one thing. I want you to know, it's not that I don't want the money. It's not that at all.
Yeah.
Some of the roads you mentioned are in the district that I serve. My only concern was I would rather send a little bit of a different message. I wish they would manage what they've got and have gotten, because they've had a windfall for the last 3 or 4 years. And we have seen in our county an example of how that's, in my view, how it's been mismanaged, and Broadway is just one of them in our county, but it's a glaring one, I think. And I've talked to folks in other communities that have had the same thing happen, and those folks aren't happy either, but I'm not concerned about them. I am concerned about Scott County, and so.
Any other, we don't have, yes, Bill?
I travel the state quite a bit, from eastern Kentucky down to south central Kentucky and to western Kentucky. And I have to agree with Rick, our state highway department has been like a bunch of sailors. I mean, they absolutely, and that's not to give sailors a bad name, they have too much money and they're on shore leave, and they have been blowing and going for 4 years. And when you start looking at towns like Nancy, Kentucky, and some of these other places are now getting bypasses, you know, we're spending money where we don't need to be. And to Rick's point, and I take his point, is that they spent money because they had it, not because they needed it, okay? I'm not against this, okay? But like Rick, I want to say that I wish they had managed what they had a little bit better, and then we wouldn't be in the situation we are now. Now, I also understand government budgeting too. I mean, if you don't use it, you lose it. I would support this resolution, okay? I'd like to know how better they're going to stabilize it.
Well, I think stabilizing, I think means, Bill.
They
that
put a
there's
floor in it.
Floor in
Okay.
it, yeah. And one thing.
There is a floor in it, but the floor
It's pretty low.
is pretty low right now, and that's what
Okay.
the governor had proposed in the last session, like the judge said, of 2014, to put the floor where it was last spring, and of course, it didn't go anywhere. I think people tried to attach a bunch of different amendments to it because it was favorable at first, and then by the time they got playing pin the tail on the donkey, it just kind of fell flat. So I think that's all they're trying to do, is to stop the floor from going even further.
So is there a ceiling now?
No, there is no ceiling. I mean, that's the other thing, is
Yeah.
Other than
the
10%,
management of the money is the issue.
10% a year.
The limit per year.
Yeah, yeah.
And we're back down to where it'd be.
It's like property taxes, you know, and taking compensating rate. If property values continue to drop, or your tax continues to drop, and you don't take compensating rate, well, then all of a sudden you find yourself where you could take 12 to 15 years to make up on that property tax. And I guess it's the same thing here, where it can fall drastically in a year, but it could take you 5 years to make up,
Get it
10
back.
years to make up that difference of what you lost.
Of the 50 states, Kentucky is 18th in the nation as far as the state gasoline tax goes, at 31 cents, 31.1 cents.
One of the things too, Bill, you mentioned those eastern Kentucky counties, several of them have to use the road money
Oh, I know.
to pay in their general fund. Now, it's a formula that they can use. They can't just take it all. That's how, in Scott County, our Scott County roads will be fine. It's the state roads, but we're talking about the whole state.
Yeah,
This
I understand.
doesn't just affect Scott County, and it's a hit for well, we're talking if everybody got an equal amount, we'd get over $1 million. And but anyway, that's where we are. Is there a motion to? Second it. Any further discussion?
Who was the motion?
David and Bill seconded. Call the vote.
Rick,
No.
Alvin,
Yes.
Chad,
Yes.
George,
Yes.
Charlie,
Yes.
Kelly.
Yes.
Bill,
Yes.
David.
Yes.
Okay. We'll forward that resolution. It's just a resolution. That don't mean it's gonna happen.
Yeah.
Thank you. Darren?
Yes, sir.
Front and center.
Thank you.
Hey, can you take one of each and pass it around? One of each? Oh. Do I have to get better instructions?
Thank you, Judge Lusby, and thank you to the fiscal court for allowing me this time this evening to come before you discussing a couple of policy changes that I'd like to see happen down at the jail. The policies, the two policy changes that I gave to you a couple of weeks ago, I'm actually giving you at this time revisions to those policies. They have a couple of additions, deletions to those policies. And those revisions and deletions have come about after conferring with our Honorable County Attorney Glenn Williams and also conferring with KACO. So, the first policy is 3100. Does everybody have a copy? It's the employment process that's utilized down at the jail. I can read the policy, but you have it in front of you. Basically, this yields many benefits to the jail, including clarity in the title of the section. And I'll just read you a quick example. The current policy states that the title of it is Written Policy and Procedures Pertaining to the Staffing of Jails, Background Investigations of Employees, Age Requirements, Compensation, and Equal Opportunity in Employment. Written Personnel Plan shall govern selection, training, promotion, and retention of jail personnel. I would like to change that to the employment process. That's the end of it. So, starting with the title, it's a much more streamlined policy. It reduces some of the unnecessary wording and what I would consider kind of clutter to the original policy. If you look at the first section of the employment process, the announcement of position, it was not in the old policy. I wanted to have it stated, although it's stated in the county policy, I wanted to have it stated that we were gonna have a specific procedure for the announcement of the policy. We have an expanded section of minimum requirements. We did not have these described as minimum requirements in the initial policy. These are the minimum requirements necessary to be a deputy jailer here in the county. Number 2, the background investigation part of the original policy. That should be under the minimum requirements. It was a separate section in the original policy. Number 4, the section of management of female inmates, which is in the original policy. That needs to be completely eliminated from this policy because it is not relevant to the hiring process, but it was in the old policy. Compensation section, which describes in the old policy that we will basically pay at least the minimum wage that is prevalent at the time, I think can be completely eliminated. So I eliminated it from the current policy because we will obviously adhere to paying the basic minimum wage, actually more than that. Number 7 of the original policy talks about a personnel plan. It's not necessary. Some parts of that are incorporated into the new plan, and there's actually no specific personnel plan that is developed by the jailer at this time or followed at the jail. We have the added minimum requirements, which I've already mentioned to you. The only items in the original policy that talk about the requirements to be a deputy jailer that are in the current list of minimum requirements, the only 2 things from the original policy are that we have an age requirement, that you have to be at least 21 years of age, and that a drug test must be passed in order to be a deputy jailer. Those are the only 2 minimum requirements listed in the original policy. You can see I have 11 listed because those are all requirements to be, according to Kentucky state law, KAR, these are all the requirements with the addition of a couple of specific requirements for Scott County. These are all the requirements that you truly need to be a deputy in Scott County. In the original policy, there is no specific process for hiring that outlines, as you see number 3 of the new policy, I've outlined the specific process that somebody will go through in order to be a deputy jailer. That is not mentioned in the original policy. So there's no standard really written anywhere as far as the specific hiring policy. It is in the new policy though, however. This new policy should specify and should have included items that are required by us, the jail, and required by state law to confirm in order to be a deputy jailer. And I'm referring to, yes, we need an application that's fully filled out by the individual, by the applicant that wants to be a deputy jailer. But we also need a copy of their driver's license. We need a copy of their high school diploma to ensure that they are in fact a high school graduate. And we would take any additional extra educational opportunities that they have sought that could be added to it. We also want to include in those required documents that they turn in to the jail with their application, we want to include a KSP background check. That would be at their expense to go and retrieve that in Frankfurt. That would not be at the county's expense. So then we would have, with each applicant, we would have a KSP background check, and we would also conduct our own background check. So we would hopefully, with the double measures, catch anything that would be a red flag for us and not just be relying on one measure to check and see what their background, their criminal background looks like. The new policy adds the new policy adds a couple more things. It adds that each application will be forwarded directly to the jailer. This is not because I have a lack of faith or trust in my staff at the jail, but I think it is good policy to ensure that as an application is turned in at the jail, that is forwarded directly to me. It doesn't get set on a desk. It doesn't get put into a file somewhere. Unfortunately, I've already spoken to a couple people that have, in the last few months, turned in an application to the jail, and we haven't been able to locate the application that they turned in. So in an effort to try and avoid this from happening in the future, I would like to see and have it as part of policy. Once they're turned in directly to me. They're forwarded directly to me. I'd like to see added, and I have added in the new policy, a minimum physical fitness standard. This is to ensure that the applicants that are applying to the jail can perform the physical duties that are necessary to be a deputy jailer. Being a deputy jailer isn't always necessarily a physical activity, but when it is a physical activity, you want to have somebody that can perform those duties. If we don't have somebody that can perform those duties, not only does it put that particular person who may not be able to perform those duties at risk, but it also puts fellow staff at risk. It also puts inmates at risk as far as being able to take care of a situation. So I'd like to go ahead and initiate a minimum physical standard, which is not, I don't think it's cumbersome. I think it is a bare minimum that we accept down there. And I also feel like by encouraging some kind of physical standard down there, I think that's going to dovetail well with the county's wellness program. The new policy will automatically extend the probationary period to 1 year instead of 6 months. Being a deputy jailer and quite honestly being a deputy sheriff are different from other county positions. There's a lot that goes into grasping the processes that are necessary to be done correctly and done well down there. And it takes a while for them and for us as the jail staff, it takes a while for them to be able to grasp those skills, and it takes a while for us to determine whether they are grasping them or not. I don't feel like 6 months is long enough. For other county departments, 6 months may very well be long enough for a probationary period. But I don't want to, yes sir, Mr. Livingston.
I was just gonna ask real quick, on extending it out to a probationary period of a year, and then reading this, it says if transitioning to full-time, the employee will receive and sign an employment agreement. My question would be, does that affect their benefits? Because we have a waiting period on benefits right now, and I cannot remember what it is off the top of my head. And I don't, would extending that probationary period affect?
As far as I know, it would affect them getting full-time status, and it would affect them getting benefits before that year is up.
So basically you would have them on a probationary period for a year, and so for that first year they're with us, they would not be able to have benefits.
That is correct.
Okay.
Yes, sir. Yes, sir. And what this probation, I'm sorry, I didn't mean to cut you off.
No, I don't know if that goes against county code and how that, with healthcare laws, how that affects. We might need to, just to clarify that.
Yes, sir.
Just to make sure, and I don't know, I'm just asking.
So, Continuing with the probationary period, 6 months, in my estimation, is not long enough to determine whether they are grasping the skills down there or not. And quite honestly, in my estimation, you're talking about certifications that these individuals are gonna have to get on specific pieces of equipment, processes that they have to grasp down there. 6 months as an administrator and knowing what they go through down there is not a long enough time to give them the opportunity to grasp these concepts and to acquire these skills and these certifications. And B, it's not long enough for me to evaluate them. So I would want to extend that probationary period for our applicants down there.
Question?
Yes, sir, Mr. Burke.
Two questions, actually.
Yes, sir.
The employees that you have now, will they be grandfathered? They not have to go through that?
Yes, sir. Yes, sir.
Okay.
Every, if I may add, every employee down there actually will be grandfathered in under the new policy, so that, for instance, you've got the employment agreement, you have the fitness standard. They're not gonna be, although they're gonna have to do the fitness test, they're not gonna be held to any kind of repercussions for not being able to
Okay.
pass it.
Next question, when you say KSP background check, you're talking Kentucky Office of the Courts?
No, I'm not. I'm talking the Kentucky State Police also do a background check. The background check that we do is through the AOC. This one is a separate one through KSP. For whatever reason, sometimes things show up on one and not the other.
Okay.
So that would just ensure me, as the administrator of the jail, that we've done our due diligence. We've done all we can to make sure that this person, their past behavior is not, should not be of concern if we hire them.
Do the deputy jailers, do they have any kind of protection under the Police Bill of Rights?
They do not.
Okay.
When you say pass a drug test, I'm assuming you're talking 10-panel drug test, or
What 10-pound drug test?
a 10-panel drug test, or something less?
Oh, 10-panel. You know, I'm not sure exactly what the drug test is that they use at this time.
Okay.
They do currently have to pass a drug test. I'm not sure of the specifics of what they have to pass, though.
Okay, I'm sorry, proceed, please.
There are a
Thanks.
couple of things that
Yes, sir.
bother me about it.
Yes, sir.
Number one, being able to hire somebody.
Yes, sir.
That, number one, if we didn't give them benefits when they started full-time, that would affect, a year's time before they'd get benefits.
Right.
And a lot of our salaries are based on the fact that the benefits are quite a good thing. And the second thing, without question, if they work 100 hours a month, they're under the retirement system. That's the law.
Right, 100 hours or more, sir?
Yeah, a
Yes, sir.
month. And now, you're not talking about hiring people part-time for a year.
I'm talking about starting them part-time.
For a year?
Well, yes.
What if they're
And-
part-time?
And I'll tell you, at one time,
Okay.
that was the policy of the county to have a 1-year probationary period. It was the policy of the Kentucky State Police when I got hired with the state police.
But they got full benefits if they were full-time.
Correct. Yes, correct.
But
Yes.
part-time people, to go into the retirement system, if they work 100 hours a month, then they go into the retirement system.
Correct, yes, sir.
Let's not forget too, that under the Affordable Care Act, anything above 30 hours is considered full-time.
Yeah.
So you're talking about limiting people to 29 hours a week.
Well, it'd be
Correct.
less than that,
Yeah.
because you wouldn't want them, you want them truly part-time, under 25 a week on average, because you wouldn't want them in the retirement system.
I don't see any way you're gonna get somebody to agree to work for a year at part-time before they go full-time.
Yes, sir, Mr. Lyons.
I think your concern on the probationary period is being able to eliminate someone without having to go through the formal process that we would
Absolutely.
after. So I think that it's a terminology problem. There could be probationary, have benefits, or be a full-time employee, but there wouldn't be a permanent employee until that probationary period is over. I think it's a language issue more than, I think we want the same thing, it's just we need to work on the language a little bit to clarify.
Yes, sir, I totally agree with you. My concern is the probationary period. I'm not as concerned with keeping them from getting benefits or allowing them to have benefits. My concern is properly being able to evaluate new hires before they're made full-time.
Because- our
So-
county employees now, during their 6 months, they're getting full benefits, but,
Well,
if
and
they're not doing their
certainly-
job,
Right.
they're out.
Yes, sir, and
Yeah.
I would be for, if the county wanted to afford them benefits, I would be fine with that. Again, my primary concern with the probationary period for me is that it's not long enough for them to grasp the skills and concepts, and it's not long enough for me to really offer a reasonable time for them to grasp them so that I can evaluate them.
I think
Yes, sir.
we may be getting lost in the weeds here. When you say full-time, you're talking a year probationary period before they're made a permanent employee.
Yes, sir. Permanent employee, yes,
They
sir,
can work
Mr.
40
Barker.
hours and be full-time, they're just not a permanent employee. Case in point, the city of Lexington, when they hire a police officer, has a 1-year probationary period, but they get benefits, on a certain, I think after 30 days with everybody else.
Mhm.
Okay? They're not considered a permanent employee until after 1 year. They finish that 1-year probationary period. So let's split probationary and full-time and kind of separate those. We're
Yes,
talking
sir.
about permanent employees. They have to be here for a year before they're a permanent employee.
Yes, sir. Thank
Okay.
you.
I'm good with that.
And that works well for me too.
And I think if we got our county handbook, we got,
Call me
if we looked at the county
employees.
handbook, the 6-month
Full-time
probation we
regular.
had, I think we could make the language match, and we'd take care of the problem.
Okay, that would be fantastic, yes. sir.
Personnel code has a 6-month probationary period with the option to add an additional 6 months. So when I talked to Darren initially about this, the 1 year, in his standard operating procedure, which he must have by statute, I think he could elevate that to 1 year and it not be out of our code compliance. But Mr. Burke is entirely correct, as well as you all, when you raised the issue of a full-time probationary period. I think that employee's got to have the benefit package and be
And-
subject to the
which again,
retirement system.
yes,
And let's
sir.
not call them full-time permanent, let's call them full-time probationary.
Right.
There you go. There you
Okay.
go. Which
And-
again,
And then when they finish the probationary, well, they're full-time regular.
yes, sir. Which again, if I may emphasize, if the county is open to giving them benefits when they become, after a 30-day or shorter period of time, I'm all for that, because the judge is exactly right. The benefits are a big part of attracting quality people to some of these jobs. They don't start out at a whole lot above minimum wage. They do start out above minimum wage, but a great attraction for a lot of these individuals that do apply are the benefits. And I would not want to do anything to impede or deter individuals from applying, otherwise quality individuals, because they would not be able to
I think the benefit
participate
package is a
in
great
benefits.
recruiting option for
Yes,
them.
sir. I totally agree.
Anybody
Yes,
that
sir.
works 30 hours a week for the county is entitled to full benefits.
Okay,
That's the present code.
okay. Thanks. The employee agreement, this is just an agreement that we currently don't have, that I would like to have new hires sign. And the language is, I don't have specific language for you, but part of that agreement would basically put them on notice and let them know that, hey, as part of your permanent employee status, you're gonna be required to pass random drug tests. You're gonna be required to pass the biannual fitness test. You're gonna be required to have no convictions, which are outlined above in the conditional offer of employment, excepting violations, of course, speeding tickets, things of that nature. But criminal violations could potentially be a violation of the employee agreement. And this would be, since attaining full-time permanent status, they would be held to this standard. Once they're off probation, basically, they're gonna be asked to continue to be able to pass random drug tests, fitness tests, not be out here getting any misdemeanor charges or arrests or felony arrests. I think that the policy helps to avoid possible discrimination claims by clarifying the minimum requirements that are needed to be a deputy jailer in Scott County. So it removes any cloudiness in that regard. It adds structure and clarity and concisement to the hiring policy down here, and it strengthens the workforce and reduces our liability. Mr. Wallace, yes, sir.
Darren, I agree with that as far as your random drug testing. Mr. Burke asked a question, would the existing employees be grandfathered in? And my question just kind of piggyback on what he asked is, would the existing employees be subject to random drug testing?
They are at this time.
Okay,
yes,
they're
sir.
already at
Yes,
that
sir.
point. Okay,
Yes.
thank you.
Yes, sir.
Yeah, the only suggestion I might offer, in paragraph number 9, the employee agreement, I don't think that runs afoul of our current personnel policy, but I might suggest that you add just a little bit of terminology, and this, no magic in this, but where you have there, the employee does not satisfy the terms and conditions of employment agreement, separation from their position may be initiated. Might, if we're gonna try to make this fit within the current personnel policy with the county, and your employees be treated as county employees, probably want to add something to the effect that if they do not satisfy those terms, then disciplinary action, including but not limited to separation from your position, may be initiated. That way it falls within the grievance procedure that we have, and it kind of flows through that policy, yet you still have that employment agreement with 1, 2, 3, 4, 5, 6, 7, the items that they need to adhere to.
I think that's a fantastic suggestion, and once again, it's the articulation. That's great. Thank you, Mr. Williams. Yes, sir, Mr.
My
Burke.
question is for Mr. Will we not want to add some type of at-will employment clause in there that addresses all those issues, that says this is an at-will employment, and if you violate these things or don't live up to these standards, separation is there?
Can, yes, yes, sir.
Okay. We're gonna rewrite this whole thing.
I'll take all the help I can get, Mr. Burke. Thank you very much.
I was gonna say, they wouldn't make the girls softball team at 16 minutes in a mile.
Right.
At all.
Are there any other questions on this particular policy?
Yeah, I had one
Yes, sir,
more
Mr.
on
Lyons.
the KSP background check.
Yes, sir.
They would have to pay for.
Yes.
That wouldn't be construed as a fee to apply in any way. Is there a problem? You understand what I'm asking? I'm not sure how that phrases.
Is there a cost to that, Darren?
There
You
is,
said there was a
yes, sir.
cost.
How much is that?
I believe it's $20, maybe 25. And if they don't get it for us, yes, we incur the cost of that. We also have to get a written consensual agreement signed by them saying that we have their consent to obtain a KSP background check on them. We then need to go ourselves to Frankfurt and pick that up.
Would there be a prohibition against, a fee for a job application is what I'm wondering. I don't know.
We probably have to pick that fee up.
Well, in the school system currently, if you want to be substitute teacher or you're applying for a full-time teaching position, you would have to get a background check
Through
at your
ALC.
expense.
Okay.
The way some places do it is that the employer would pay for the background check and the drug test with the understanding that if the employee did not meet the criteria and finished their probationary period, they were terminated, that those fees would be deducted from their last check. So the county's not out of anything out of pocket for a bad employee, but you still pay for the good ones that you keep.
Yes, sir. And I would be open to either, as long as we're introducing and implementing some kind of double way to check their background, as opposed to relying singularly on one system to check their background. With that, Mr. Burke, though, we would be incurring the cost and physicality of having to go to Frankfurt and get it, and certainly be having to get them to sign a form to allow us to get that.
Or they pay for one and we pay for one.
Were there any other questions in regards to this specific policy?
I think it's excellent, Darren. I appreciate it, and fine tune that a little bit with Glenn.
I'd be happy to.
It's very impressive.
Great, thank you.
I have one thing I wanted to mention about, on number 8, the extension of probationary period. To me, Darren, that is going to create a separate class of county employee for them to have a 1-year, 1-year probationary period. And I think it's a slippery slope for us to start on. And I think 6 months is adequate. That's been the standard. And I'd like to see us stay at 6 months.
With the option of an additional?
It's got an option of additional.
Adoption, okay, an
Yeah.
option.
Yeah.
Yes, sir.
But I think that it could hurt us in recruitment. I think that, like I say, it could cause internal complications, being that you set this standard for these county employees and these county employees. You know, we've been down, in past years, we've been down that road before, and I'd like to see it stay at 6 months.
Yes, sir, if I may respond briefly. I do feel like, with all due respect to my fellow county employees, I do feel like there is a little bit of a difference between the jail and the sheriff's department and the other county employees. We do participate in hazardous duty, so we don't have to work as long to attain retirement benefits. I think that the nature of our jobs are such that we want to, as with every county job, but certainly with these two offices, we want to hire the absolute best that we can get and make sure that they have the best judgment, that they are acquiring the skills, because we have in our custody at the jail, and certainly the sheriff's department also has in their custody for periods of time, persons, and we need to recognize that that's a great responsibility. And so I feel like, in my opinion, 6 months is not long enough to evaluate their judgment. Again, the grasping of the skills, the grasping of the concepts down there. So I do think we are separate. A little bit of separation is justified from other county employees, but equal to other county employees. I don't put the jail or the sheriff's department above any other county department or any other county employee. But I do think, because of the requirements of the job, we have to take that extra step to make sure that these individuals that are charged with the custody of those that get arrested here in Scott County, that their judgment is where it should be. That, again, their grasping of the concepts and skills down there is where it should be. So for those reasons, I feel like that we need an extended period of time at the jail. And to Mr. Livingston's, or maybe Mr. Williams' suggestion, that we can just extend the 6-month period, we can do that. It would be my concern that if not everybody gets extended, if we extend everybody, then it looks like we're just rubber stamping the policy and circumventing the policy that's in place anyway. Second to that, if we don't extend it for everybody, then are we going to be called into question as far as, are we discriminating against anybody because somebody is getting extended here and somebody else is not getting extended? So I feel like not extending it, you've got those two caveats that we need to kind of be careful about. Mr. Burke, yes, sir.
I want to say that I fully support what you're doing, and I fully support your 365-day probationary period. There was a time in my life where I spent a lot of time in the Army, and I can tell you the price for failure for people who don't know what they're doing, who haven't been in their job long enough, is catastrophic. And the name of the place was called Abu Ghraib, and we all know what happened there. And these were military police folks who had been on the job less than 3 to 6 months. And things got out of control, and things got crazy. And our country paid the price for that. And I'd rather not see that happen in Scott County.
If for some reason, Judge, in the fiscal court, we were to determine that this was negatively impacting our recruiting, I can always come back to this body, and I don't want to encumber this body any more so than what I already am. But it can always be revisited by this body at a later date if it is negatively impacting our recruiting. Were there any other questions on this first policy? If I may, I'd like to move on to the second policy. This second policy is a policy that the jail has about the criteria for refusing individuals into the jail. This particular policy is, like the hiring process, one that affects us immediately. And I can tell you, one of the first things that I started doing when I got into office on January 2nd, I won't say January 1st, but on January 2nd, is a start of a review of all of our policies and procedures to see how recently they've been updated, to see if proper protocols were being implemented, to see if the protocols that were listed in the policies and procedures, to see if those were being followed. And with this particular policy, I can tell you that the policy was not being followed at the jail. And that is, obviously opens all of us up to liability. So I have brought these two policies up to you all as immediate concerns of mine. The hiring process, because that affects us immediately, and then the acceptance or refusal of individuals into the jail affects us immediately. As I stated in my cover letter to you all, I would like to have to you all by the springtime a revision to our SOPs. But these two particular policies impact us immediately. This policy of refusing persons into the jail, there's a couple of different reasons why we can refuse people into the jail. The original policy, it was a little bit awkwardly written, so it has been not watered down, made more concise and streamlined in order for the staff at the jail to fully understand it. And it has added provisions in there so that they can follow the policy, which again, they were not doing at the beginning of the year. If you can look at the first page of the policy for refusing persons into the jail, there's clarity again in the title or the standard at the top. That was reduced down. Again, I read the first policy, that title, it was very long, very cumbersome. This one was similar and has been reduced down to refusing persons into the jail. That's for ease of understanding of the staff. That concisement, that clarity is in that title, and it's in this policy so that they can clearly understand the policy and thereby clearly be expected to follow the policy. In the procedures, we have discussed the observation, the importance of having observation of the arrestees. In the original policy, that was also in there. It has just been moved away from its own separate section, which it didn't need to be in. It's just been moved under the first part of the procedure. Also in the original policy, one of the sections include a discussion of refusing persons in that have serious injury. It's not determined, it's not defined in the original policy what serious injury is, so it's very open to interpretation. It's too open to interpretation in my eyes. In the original policy, there is language of individuals with minor injury. I have removed that based on it also being too vague. And the whole idea of accepting somebody with minor injury, I don't think should even be in this policy. This is supposed to be about refusing persons. So a separate policy that talks about the booking procedure. If somebody has minor injury, yeah, we take individuals with minor injury down there, but it shouldn't even be in this section because this section is supposed to be talking about the refusal of persons. So I removed that out of this section, again, in an attempt to bring concisement and clarity to the policy, to remove what was not necessary in this particular policy. Added under the procedure, which is the first paragraph of this policy, we have added that, and it's the last line, actually, the last full line, excuse me. In the last line, it says, in those instances, a written medical evaluation and clearance is needed. The prior policy says that we just need a medical clearance, a medical evaluation and clearance. It does not say anything about having a written clearance, a written evaluation by medical staff at the hospital. We require at the jail written clearance. So we have something from a physician saying that this person is medically clear to come into our custody at the jail. So it was added, that line had written added into it so that the police officers would be required, and they're required now, it's just not in policy, to get a written evaluation and medical clearance from the hospital and the attending physician. Under Procedure 1 of the old policy, it cites an alcohol level of 0.24 as determined by the intoxilizer. Well, the intoxilizer, or commonly referred to as the breathalyzer, is not used in every alcohol-related arrest. Most of the time, and I would venture to say 75% of the time, the refusals that we have are not based on a quote-unquote breathalyzer or an intoxilizer reading, which again is the instrument used in DUI cases, but it's on a PBT, which is a preliminary breath test. It's a portable little machine, either by us or by the arresting officer, which gives an accurate reading, but it's not the same thing as an intoxilizer reading. Current policy says we'll get an intoxilizer reading. We will refuse persons that have an intoxilizer reading of 0.24. Well, we're refusing them right now on a PBT reading of a 0.24 or higher. So I have added that it will be an intoxilizer reading or a PBT reading into the language of this policy so that we may use the intoxilizer or the PBT. We're not allowed, the state police owns that intoxilizer down at the jail. We are not, according to their policy and procedures, we're not supposed to even use that machine for anything but a DUI-related arrest. So even if we wanted to go in and let them blow into the intoxilizer to yield a result for us to determine whether they're above or below the legal limit or our limit to come into the jail, we can't even do that unless we want to risk violating the procedures that the state police have for us. The intoxilizer is supposed to be for DUIs only. So most of the time what's happening is these alcohol-related arrests many times are determined on a PBT, either our own or the arresting officer. Again, it wasn't in the language before that we would use a PBT result. Now I've entered it in here that we will use PBT results, and it can be, if we have an intoxilizer reading, we won't even do the PBT. We'll go based on the intoxilizer reading, which is a better instrument to be determining their alcohol level. It's more accurate. Yes, sir, Mr. Livingston.
So you went from a 0.24 to a 0.30.
Correct. Yes, sir. What I would like to see us do is raise that limit from a 0.24 up to a 3. In my 20 years of law enforcement experience, I believe 0.24 is too low to just prima facie say you're too intoxicated to be in this facility. I think it's too low. Now, do we need a standard where we do say, hey, anything above this limit we're not taking for medical reasons? We're not going to take this because it's a medical concern of ours. They need to be medically cleared. So I definitely believe, obviously, that we need a level where we have prima facie determination that they're too high. But 0.24 is low. In my opinion, it's too low. I think that it creates a burden for the county. I think it creates a burden for the city. It creates a burden in many ways. The police officer, if we raise it from 0.24 to 3, I believe we'll eliminate probably 75% of the refusals that we're currently imposing on the police officer that brings in that particular arrestee. Right now, when the person gets refused, the police officer, whether it's state, county, or city, has to then take that arrestee to the hospital and get them medically cleared by an attending physician down there. What that does is it ties that police officer up for that period of time, depending on the busyness of the hospital. It could be a 45-minute to an hour time frame. It could be a couple hours time frame that they are off the street, not able to do the job that they're supposed to be doing. It burdens the hospital with having to do these medical clearances, and while they're getting compensated, it is a burden to them to have these brought in occasionally and require the attending physician to take time to clear them. I think that the financial burden is shared by all of us. Sometimes there's a form at the hospital that is supposed to be filled out to where if it's a refusal of the jail, it's supposed to be filled out and the jail receives that bill in the mail. Now, the minimum cost for a medical clearance at the hospital is $386. That's if they don't do anything else. That's if they don't determine any other issues or admit the person. That's if the doctor goes in, does his evaluation of them, and clears them relatively quickly. So that burden is, if all things are done according to protocol, that burden is being put onto the backs of all the citizens of this county, and I would submit to you unnecessarily. The jail staff is very qualified to handle the custody of individuals that are a .24 to a .3. They're trained in their observation. We have surveillance equipment down there to help with the observation of these individuals. And you know, just because somebody doesn't blow, and this is in the policy also, but just because we don't have a 3 for, just because somebody doesn't blow a 3 or higher, if we go to that limit, or we can use the .24 limit that we have right now, just because somebody doesn't go over that limit, whatever limit that is, that does not take away our ability to refuse that person anyway. If we have somebody that comes in, I'll use an example, a college student over here, maybe a 19-year-old college student comes in and they're at a 1.8 or a 1.9 or a 2. That doesn't meet the limit as far as automatically refusing them, but if they come in and they're staggering or they're so intoxicated that they can't answer simple questions, and I've listed a couple of these in the policy to give the staff an idea as to what to look for. This list is not all encompassing. There could be 100 different things that you look for. We had somebody that came in last week that was intoxicated, but it was drug-related intoxication. So you're not going to get a reading, an alcohol reading at all from them, but we took the person in, got them booked in, and through the observation of the staff down there, they recognized by checking on him that his eyes had rolled to the back of his head. They couldn't see pupils or anything. I would consider that a medical emergency. They went ahead and got his attention, brought him out of his, not quite a catatonic state, but his state that he was in. We got him down to the hospital, and he had illegal narcotics in his system and was a potential candidate for an overdose, but did not happen because of the diligence and observation of the staff. So, but that person, we didn't have an alcohol reading on them. If they had blown into, say, a PBT or an intoxilizer, it would have been 0. So this policy in no way impedes us or prevents us from using our training and our observations, our skills that we develop down here. It in no way impedes us from refusing persons still. This level is just an automatic refusal level. This, in our determination, is too high for us to accept at the jail. Below that, we're comfortable with that. All other things being equal. In this policy, obviously, it states that alcohol reading is just one thing that they look at. And just like this individual, Mr. Livingston, the drug-related individual, again, no alcohol reading, but other indicators indicated that he needed medical attention, and he got it. The other thing I would submit to you, sir, is that other detention centers in our area utilize the .30 level as a standard to go by. And those facilities are smaller than ours, same size as ours, and larger than ours. We've got Fayette County that uses this standard, Madison, Jessamine, Woodford, Shelby, Nelson County, all in central Kentucky, they all utilize this standard. So I think that it would reduce a burden to the officers and their departments. Late at night, the sheriff's department and the city department, for that matter, only have a certain number of officers out. To unnecessarily tie them up for 45 minutes to an hour or 2 hours, I think is an unnecessary burden to place on those departments, let alone the financial burden that we're placing.
I don't disagree with you. I was just curious about raising it, because
Yes.
that's not my expertise. You're the professional, so
Yes,
if you're
sir.
comfortable with that as the jailer, that's your prerogative.
Further down in the, under the procedures The number 3 under the procedures at one time said instead of ingestion of foreign substances, it said, if I may quote it quickly for you. It had a multiple substance abuser, which means, in my eyes, if we know somebody's a multiple substance abuser, not that they have currently ingested a multitude of foreign substances like alcohol and drugs and things, but if we just know them to be a foreign substance or a drug abuser, multiple substance abuser, we can refuse them. Well, that's erroneous to just refuse somebody because in the past they've been a multiple drug abuser. So I clarified that in that we have the ingestion of multiple foreign substances. So drugs, alcohol, combination of those would qualify. The adding also of, which is number 5, the adding also of the individual failing a Scott County Detention Center administered drug test. That is part of our current refusal policy, but it was not in our written policy. For instance, if somebody comes in to serve weekends and they come in, they're given a drug test by protocol, they fail that drug test, then they refuse them down here by protocol, but that's not in the written policy, but it is in their unwritten policy. So I went ahead and added that in here.
So what happens to them if they're coming in to serve on the weekend and they fail a drug test and you turn them away? Where do they go?
We get them a court date and they are scheduled to appear in court in front of the judge.
But we have a free weekend.
Big trouble.
Yes, sir, yes, yes.
Nothing wrong with it.
In my opinion, the current policy of the .24 is too low. It's not consistent with other detention centers in central Kentucky. It does cause a physical and financial burden on the city, county, and state, and the hospital. And it requires the officer, which I didn't even mention, and this is more in regards to the arresting officer than affecting us at the jail, but quite honestly, it forces that officer to take this individual who he's had secured in his car. Now he's in a secure facility. If we refuse him, he's now forced into, in my opinion, a more dangerous situation by having to take this person out of our secure facility to a hospital, which is an unsecure facility. And I don't for a minute doubt that any of our city, county, or state police officers here are capable of handling the situation, but I don't want to unnecessarily put them in that precarious of a situation as to if we don't have to. Currently, I mentioned other counties in the area utilize this standard. The cost is $386 minimum per refusal down at the jail. And of course, I already mentioned in responding to Mr. Livingston, this in no way impedes our capabilities to refuse somebody at all. This just basically affects the automatic limit that we say you're too drunk to be in here, and that's it. So I think this will yield a reduction in costs to the taxpayers of the county. I think that it will eliminate unnecessary work for our local officers, including state police officers that cover our county. It will eliminate unnecessary work for the hospital. And through this policy, the way the policy is written and newly structured, it adds clarity and concisement to this particular policy. The one other thing I would add that was not in your all's original copy, and I've tried to make a notation for a couple of these additions that you did not have in the original policy that I got you all. But if you would look to page 2, it says that any of the refusals that we have down there, and the refusals are done by the shift supervisor, a notation of that refusal will be made on the intake sheet. That is a sheet that is filled out by the officer when he's brought in. So if we have to refuse them, either a note will be made on there, which there is room for that to be made on that sheet, or a denial of admission form will be filled out by the supervisor of the shift. And either one of those suffices the paperwork from my standpoint, and that will then be placed in the permanent file of the arrestee. I'm sorry for being so long-winded. Do you have any more questions?
One question.
Yes, sir, Mr.
Do you
Wallace.
have an estimate of, or a record, it's hard to go back and look in the past, I know you're changing this going forward, but about how many inmates or people who are brought to the jail would go from a 2.4 to a 3.0? Because I'm kind of looking at it from a savings standpoint about how much money that it would save the
Yes, sir.
taxpayers of Georgetown, Scott County.
Quite honestly, I asked the staff to try to make that determination for me, expecting that to be a question, and they couldn't make the determination based on the paperwork we have at the jail, how many of those were in that range.
Okay. Thank you.
Yes, sir.
So if we save two, we've saved almost $800.
At a minimum, Mr. Burke,
Yeah.
at a minimum.
Yeah.
Let alone, if I may add, let alone the wasted time of the police
Yeah.
officer or whatever time.
Making our police department more efficient and.
Yes, sir.
and the jail more efficient and saving taxpayers money.
Yes, sir.
I'm good with it.
Thank you. Were there, yes, sir, Mr. Hoffman?
Yes, would you, on number 4, what is the definition of a mentally ill person as per those, codes there, 202A?
Right, 202A is the state law that's referencing with the definition in the state law. But mentally ill, it could be somebody that maybe is not, I hate to use the term certifiable, but that is certified, I guess, by a clinical
Diagnosed.
psychologist. Yes, sir, thank you. A medical diagnosis. It can go beyond that. It can be if in our determination or the officer's determination, this person is mentally unstable or concerned. And one way that we evaluate that, a clear-cut way that we evaluate that, and this person that would make this statement would be refused down there, is if somebody threatens suicide.
202A is a statute, Mr. Hoffman, that is geared toward helping people that are either a danger to themselves or others. And incarceration now is not the option. Not to say that a person that commits a crime is incarcerated, then starts showing traits that Darren has just mentioned, can't be taken to closest facility, obviously, is Eastern State, for up to 72 hours for an evaluation. There's a petition that can be filed that's presented to the district court judge. Our district court judges would review that petition. If it warrants that 72-hour evaluation, they sign an order and they're transported by whomever the agency may be that has custody of that individual. But the 202A, as Darren says, has standards, but essentially it's for anyone who is exhibiting traits that they're a danger to themselves or others.
That's a good safeguard policy.
It is, yes.
Are there any other questions?
Is this gonna be part of the standard operating procedures? Is separate?
Judge, it's gonna be part of the new policies and procedures manual that we have in a few months. What I would like is to immediately add it in and replace the old policy with this policy.
That's what I don't see a problem with what you've got here personally.
Were there some things that need to be clarified on 3-100 or?
Yeah, my take is, and Darren, you correct me if I'm wrong, the refusal amendment can be adopted tonight. That gives you immediate effect as of tonight.
Yes, sir.
The employment process may need to be fine-tuned just a little bit.
Yeah, and I'm very accepting, very open to any suggestions from this body or anyone else. If it is okay with you all, I'd like to, on 3-100 that Mr. Livingston just mentioned, I would like to confer with Mr. Williams, get some of the more specific language that he and Mr. Burke have suggested into the policy, and bring that back to you, if I may, next month or if that's okay, in February, Judge.
What we need now, I think, is if the court agrees to adopt this refusing persons.
Does it take one reading to do that? Or would-
That's just.
That's just a standard policy, yes, you
I
can
move to
approve it tonight.
Rick, second. Any,
4-100.
any further discussion? All in favor? Okay, this one's adopted.
Thank you, Judge. Thank you to this body for your time. And I apologize, I'm still a little bit under the weather, but I'm confident I'm not contagious. So, thank you again.
We continue the discussion on the constable lights and siren, and Glenn has put together some standards that we might want to adopt or might not want to adopt. Mr. Burke has also added some things that he thinks might be needed, and it's open for discussion now. Who's first?
What I sent you is just a compilation of some things that I ran across through some information that was provided to me primarily through Franklin County. I did touch base with KECO. There were some good recommendations coming from Rich Ornstein, and by no means are these the only things that can or should be considered, but these are just talking points that I thought might kick off the discussion. The areas that I know are really important in my estimation, Mr. Livingston touched upon it at our last meeting about insurance. You'll note that this was back in 2011. KECO indicated that those ranges were from anywhere 300,000 to 1 million. But the other ideas there are merely points of discussion, and by no means would be a complete list.
If we adopt these policies, number 2, I would suggest that the constable must have proof of having at least 5 years' experience in a recognized law enforcement agency out of the last 10 years or so, not something that happened 30 years ago or something, because the laws changed. But
I think the biggest hurdle is going to be car insurance. Because I talked with 5 different companies, and if you have just a regular auto policy, like your home and auto, and all 5 companies said that they would not insure a vehicle with permanently affixed lights.
On a homeowner policy.
Yes, on a regular auto policy. So they would have to go and purchase a commercial policy to be able to have that coverage.
that would be under number 5.
Yes.
Yeah. That would, but he could get could get it under
Could.
commercial.
Yeah.
Be-
How many, ask a question,
Sure.
do we have any constables now that have blue lights on their cars that we've given permission?
They can put them on the car, they just can't turn them on.
Okay.
But they're not supposed to turn them on.
But have we authorized anybody
No.
to use
Yes.
this? Okay.
Not since we've, they've.
Not since we've been
No,
on the
but
court.
Well, no, I understand.
Not current, or not
Gerald,
in the last 4 years.
we have some that were several years back, right?
Yeah, I think we currently have 3 constables that had come before this body. I don't know what the requirement is as to how often they have to come and ask, if it's every year or once they get it, they've got it. I'm not sure. But we currently have 3 that I know that came before and got permission to operate their blue lights 2 elections ago. So it would have been
before
the
we
term
were here.
before you and Mr. Lyons came to the court.
Gerald, do you know if those constables that have lights have had experience in law enforcement?
Those
before?
3 are all retired Georgetown police officers.
Okay.
What's the situation they would use the lights? I'm not really positive I know what the constables do and when they would need to have that.
I don't know if that's a fair question to ask Mr. Porter, because he's with the sheriff's department, he's not a constable.
Sure.
So I don't want you to be on the spot of speaking for constables.
I'm not gonna be in a position of speaking for the constables. The only thing that I would say, what you guys end up doing and the policy you adopt on this is obviously up to you. That's not the standard. But as far as to somewhat answer the question, Mr. Corman, you were bringing up, I know the 3 that do have them have been authorized. I think there are only 2 that actually have put them on vehicles, and I have never seen them actually turn them on. I think it was just a part of doing it that they had asked to have it done, kind of thing. But apart from that, and this is not to influence the body one way or the other, or to denigrate the office of the constable or try to step into whether or not they should or should not be allowed to do whatever. But our feeling on it is that we provide the law enforcement and safety aspect of the things needed, we feel like, within Scott County, as the Scott County Sheriff's Office. We don't foresee, or that I can obviously remember straight off of the 21 years I've been here, have been in a position where we were required to utilize a constable in a situation like that. And we don't necessarily see that we will need to. Again, that's not to say whether or not they should or should not have the lights, or that they are or are not needed. Just our position is that we provide that service for Scott County, and don't necessarily see that it needs to be supplemented.
So we have two that
There are 2
have approval.
currently that have them on their lights. One has a fully marked vehicle, because constable, the markings on it.
What
light-
district?
The light bar on the top. It's, I'm not sure what district, it's Bobby
Okay.
Townsend.
6.
And the
What-
other one has an unmarked vehicle, with the lights on the inside of the vehicle.
So I don't think we have a choice as a court to think about, we have to think about passing it and what we want to do, and hold all of the constables to the standard, including the ones who have prior permission. And what I'd like to know is, do you have to get permission after every election period? Because you have to go through the election period every 4 years, so do you have to have permission each time you're reelected?
Statute doesn't say.
Okay.
It's under 189-950, but
Is that something we could institute?
you put that in your policy.
Okay.
Because it says in here, any constable may, upon approval of the fiscal court. So I think the fiscal court can adopt its own policy, and then it must be met. But as far as the statutory requirement where it says annually, every 4 years, every 10 years, it really doesn't say that. Or at least I have not found anything to that effect.
You're all quiet.
One scenario that
I wrote my epistle and
came up in my mind about the usage of the blue lights by the constables. If a constable was out in the county and happened to be the first person up on a wreck, and we prevented, he has blue lights on his car, and we prevented him from turning those on and positioning his vehicle in a place where oncoming traffic from behind did not see. Would we be liable if there was a crash from behind? Because you know there's a lot of, it happens a lot. I mean, we've all seen it on the videos on TV, oncoming traffic hitting a disabled vehicle or whatever. If we limit a magistrate from doing that, a constable, yeah, right. A constable from doing that, I don't want blue lights on my car.
I'll give you some.
But if we did, would there be a liability of the county for, I guess, hamstringing their abilities or whatever to take what I'm sure the law enforcement community would say would be the appropriate, appropriate action to prevent that? Because I think that's happened here in the county in past years, or long time ago that happened here in the county, and would that put a different,
Charlie, can I tag on to that
Sure,
for just a second?
sure.
First off, almost every vehicle on the road has emergency flashers right now, okay? So certainly a constable could use those. Is a constable a county employee?
No.
Okay, so if a constable is not a county employee, and he doesn't turn on blue lights, then the county's not on the hook for anything. But under the Good Samaritan rule, he would stop and render aid. I would stop and render aid. You would stop and render aid. I think we all would. I don't think blue lights make a roadside accident any less hazardous until the sheriff's department or police get there, or emergency, services. And you can do that with red and white lights too. You can do it with just plain white strobes. But if a constable is not a county employee, and we have not given him authorization to use blue lights, I do not see where the county would be on the hook for anything. Now, my next question, who does a constable work for?
Well, that's true. That's true. But the reason I asked that question is that I know that the sheriff's department, that's the standard that they use. And I mean, if we prevent someone that has, by constitutional, I guess they have arrest powers and they have duties or whatever to maintain public safety in that type of situation, and they don't have those lights on, and a truck or a car comes by and hits them while they, while they're disabled or whatever, and it possibly could have been prevented because of positioning of that vehicle with blue lights on it, or that's determined. Would that be cause of,
I don't think it puts the county on the hook for anything. I mean, we have a county deputy sheriff, Jeff Holland, who was sitting in his cruiser on the side of the road with blue lights on. He got rear-ended by a tractor-trailer truck. So blue lights don't necessarily mean an accident's not gonna happen.
Charlie, my response to that would be, there would be a much greater risk of liability of authorizing blue lights and have somebody go out and use them improperly,
Yeah.
either
That's true,
through
too.
causing an accident or just making unlawful stops, and that type of thing would be a much greater risk of liability from that than the situation you're talking about. So I think we need to have a very firm policy in place before we authorize any more. I didn't know, like I said, we've not done any since I've been here, and so.
Well, that's why I asked the question, do we have any others out there that have blue lights on, and do we grandfather those, or do they fall under this new policy, or what do we do?
Glenn, so if this body authorized the use of blue lights by constables, does that put us in a liable position?
Potentially. There's an OAG opinion that's part of the information I provided to you. This is an 86 opinion, so it's got some age on it, but it essentially says for a fiscal court to be liable for wrongful conduct of a constable, the wrongdoing by the constable must be directly attributable to the use of blue lights or siren, and the fiscal court must have acted negligently in approving the use of those blue lights under this section. What that tells me is that if we don't do something, or if the court doesn't do something to have a policy, just unilaterally grant the use of it, and then there's something that occurs, I think this court's looking at some liability.
So what we've got to essentially do as a body is figure out if the benefit outweighs the liability. And that's what each individual has to figure that out.
Chad, I think we're in more trouble without a policy than we are with one.
Possibly.
I have a suggestion. Why don't we have a couple of us work on it?
I would think.
I'm
that
not
would-
volunteering. I'm just
You know, when you bring up
saying, why don't
something.
we have a couple people work with
Well, Bill has.
Mr. Williams and the
it's
judge and-
Trades on the track, right?
Yeah.
Trains on the track. I would think that's a great idea. And Bill, would you be willing to do that? And who would volunteer to go with Bill? All right, Rick, and take what Glenn has got and the ideas you had and fine tune them, and we'll see where we are.
Okay.
And you might even want to think about having some of the things that the jailer has in his, with regards to tickets and DUIs and
They have to cross a criminal background
Yeah.
check before we get blue lights. Arkansas had a case where they had and I'm talking, probably 15, 20 years ago, they called him a blue light rapist, and the guy was an ex-constable. The guy voted out of office, and he was still driving up and down the road, pulling people over.
We haven't had any cases that bad, but we've had some close. So not with the current ones, but in the past. That's a great suggestion, David, thank you. We'll move on. The courthouse cleaning, the lady that has cleaned the courthouse for the past decade or more is off on, she's sick leave, and the lady that has been replacing her, next week is the last week that she's going to work, and trying to come up with some way to keep the job open but keep the courthouse clean. And what I would like the court to authorize me to do is to advertise for a cleaning company to clean the courthouse until we determine, what we're going to do in the future. But I don't want to close the position and hire somebody full-time until we get to that point. And we'll advertise and go from there and see what it costs. And
So we would make a motion to hire temporary cleaning service.
is there a second? All in favor? Okay, thank you. One in the opposition, okay. David brought in, the county judge can authorize magistrates to perform weddings. And there's a form you have to fill out, and I guess David brought that form.
I've got a letter from last time, from the past 4 years, but I didn't know if it needed to be done again or.
Well,
I don't know.
I'll be glad to do it,
I'd like to do it.
since
4 out of 6 haven't worked, so I don't have a good.
John T had a going thing, and since he's gone, we'll need some people to perform weddings. And get the form to me, and whoever wants to do that, I'll be glad to authorize it and file it with the clerk, and she'll send you plenty of business, won't she, Rebecca? So, all right.
I've already had somebody ask.
The February workshop is the same time as the CAECO meeting in Lexington. We've got 3 choices. We can have the workshop and miss the CAECO meeting. We can cancel it, or we can change it to a different date. And in the past, of course, we didn't have 5 new members either. We have, on these kind of situations, just canceled the workshop. But that would kind of be my suggestion, but whatever you. I think, how many's going to the?
Yeah, I've already signed up, I think.
I think everybody's going, so you're not going. Okay, so Chad and me and you could meet. I'm going to that. Okay. Do you want to cancel the workshop?
Yes.
Okay, is that your motion? Is there a second? Okay, all in favor? Okay,
That's the 6th, is it not, Judge?
that's,
February 6th.
I think it's correct. The executive session will be at the next meeting, not this meeting. So those are all the items that I have on the agenda. Does anyone have anything to bring forward to court? Anyone? Mr. Livingston?
No, sir.
Mr. Burke? No.
No.
Mr. Alvin?
No, sir. Tired.
All right. Me too.
There's a blood drive at the extension office tomorrow, starting at 10:30, I think, around to 4 in the afternoon.
Thank you.
Yes, sir.
Nothing wrong.
Stacy? Being no further business, we stand adjourned.